my name is Kim Cullen, and I'm a personal injury lawyer in Orlando, Florida. As a result of what I do for a living, my attention tends to be drawn to media reports about car accidents. And one of the things that I've noticed about almost every car accident that gets reported in the media is that the news report almost always includes some sort of reference to whether the accident victim was or was not wearing a seatbelt. To me, it seems like this information is included as an implication that whether or not the person was wearing a seatbelt had something to do with whether the person deserved to be injured or not. Don't get me wrong, wearing a seatbelt is one of the simplest and most important safety measures that any driver or passenger in a car can undertake. And it's definitely a good idea for every passenger in a car to be wearing a seatbelt. But wearing a seatbelt is not the end-all be-all in determining whether a person has a claim for personal injuries. Wearing a seatbelt is just one of several factors that a jury can take into account in determining the cause or the extent of the negligence of the injured person. Of course, the jury also gets to look at whether the negligent driver or the person that caused the accident was speeding or was a careless driver. And the jury puts all of this together and decides what percentage of fault will be directed to the injury victim and what percentage of fault will be directed to the negligent driver. In short, just because a person was not wearing a seatbelt does not mean that that person doesn't have a legitimate personal injury claim or is not entitled to money damages. If you have any questions regarding an accident involving a seatbelt issue, feel free to call me at my office, 407-254-4901, or you can always visit my website at www.cullen-law.com.